Thank you very much, Dean Rutherford, for the nice introduction, and Nikolai for the wonderful arrangements. I'm very honored to be here. I had a wonderful tour of the Clinton Library this morning, which was very exciting, and some former students of mine drove me past Central High School last night so I could take a look at that, since I've been teaching about Cooper versus Aaron for 20 years now, so that was exciting for me as well. I'm sure many of you would like to talk about the current Supreme Court and some of the most interesting cases and hot topics, and I would be happy to do that in the question and answer if you'll indulge me maybe 20 minutes of history first, and then we can talk about what's going on in Washington today. Let me tell you a little bit about Justice Brennan and why I think he's so important, why he still matters, and what my research for the book taught me about him and about the court, and given our setting, also about the importance of public service. Justice Brennan was on the court from 1956 to 1990, 34 years. We suggest in the book that he was perhaps the most influential justice of the last half of the 20th century, if not maybe the whole 20th century. He was not the greatest thinker in the history of the court. He was not somebody that people put in the category of intellectual giant. When he first sat on the court, he sat with people like Felix Frankfurter, Hugo Black, John Harlan, William O. Douglas. People consider those to be the sort of great intellectual giants of that era of the Supreme Court. What I argue in the book is that they may have been the great intellectual thinkers, but Brennan was actually the best lawyer in the group. And that was important to his success. While the others were envisioning great constitutional thoughts, Brennan was the one who was figuring out how to get it done. And what he got done was a remarkable legacy. If you look at almost any civil rights or civil liberties issue today, you will find Brennan's legacy in the middle of that issue. Dean Rutherford mentioned abortion rights and First Amendment rights. There are many others as well. The reason that gender discrimination is now prohibited by the Equal Protection Clause of the Constitution is a Brennan opinion. The reason that we have as broad and robust a vision of free speech in our society is largely thanks to Brennan opinions. Freedom of the press is really a legacy of Brennan's opinions. A whole range of individual rights and liberties, protections under the Fourth Amendment involving various police and law enforcement procedures are all part of Brennan's legacy. And so I want to talk a little bit about why that's the case. What is it about Brennan and the time in which he served that made him so significant? And in the course of doing that, maybe tell you a little bit about how my book came to pass, which is where I want to start for a minute. I was the Supreme Court reporter for the Wall Street Journal in 1986 when I was approached by a good friend of mine who was then the chief judge of the appeals court in Washington, a man named Abner Mikva, who later served as one of President Clinton's White House counsels for a year. Abner Mikva asked me if I wanted to write a book about the Supreme Court, and I immediately replied, absolutely not. What I didn't know then and didn't discover until later was that his close friend, Justice Brennan, having reached the point of serving for 30 years on the court in 1986 and reaching his 80th birthday, had decided that he wanted to have a biography. And so he was in the market for a biographer. I didn't know any of that. Abner Mikva led me to believe that I was going to go meet Justice Brennan and sell him on the idea that he should have a biography and that he should pick me to be his biographer. And you know, there are lots of things I do well, but I'm not that good a salesman. And I was pretty sure that it was kind of a futile effort. I prepared for weeks and weeks and weeks. You know, imagine the most important meeting or occasion you've ever gone to in your life, and you've got to go make this sales pitch. And I went into this meeting after preparing for weeks and weeks and weeks, ready to try to make the pitch, and Justice Brennan came out from behind his big desk and shook my hand warmly and said, "Well, I'm ready to go, Steve. How about you?" That was the extent of my sales pitch. He had checked me out with a whole range of people that I didn't know was going on and decided that he wanted to do the biography. He then incredibly generously made himself available to me for 60 hours of tape-recorded interviews, which I'm working on trying to get digitized and available on a website for future scholars to be able to use and listen to. And I had the opportunity to talk with him about everything. I mean, ask him every question imaginable. It was a wonderful opportunity. It gave me incredible insights, at least through his eyes, into how the Supreme Court works. And it's a few of those insights that I want to turn to now in 1 second. The other part of this was that over time, he gave me access to all of his papers and files, and it's a remarkably rich resource of material, in some ways unlike anything that has ever existed in the history of the Supreme Court. Many Supreme Court justices keep records and files of the cases they worked on. Those files include draft opinions and memos exchanged among the justices. They also have correspondence files, letters that they wrote or that people wrote to them. Brennan had all of that, but in addition, he had a remarkable third set of materials which he called the term histories, and those are the ones that are unlike anything ever before or since in the history of the court. Beginning in 1960, so after he'd been on the court for about 5 years, and for the next 30 years, he had his law clerks write out a narrative account of every major case of each Supreme Court term for 30 years. Here's how the case came to the court, here's who voted to hear the case, here's why, here's what the justices said to each other about the case when they were deciding to hear it, here's who got assigned to write the opinion, here's how the case evolved. It's a remarkably rich account of the operations of the Supreme Court over this 30-year period. I'm not a trained historian. I will tell you that while it is also a remarkably rich account, it is also problematic. It is filled with gossip, second and third-hand accounts. I mean, here's a typical passage. Justice Brennan learned from his law clerks that Justice Powell's law clerks had heard from Justice White's law clerks that Justice White was thinking of changing his vote in a case. Now, you don't have to be a trained historian to know that you probably shouldn't touch that with a 10-foot pole unless you're going to go to the trouble of following the whole trail to see if it really happened that way. Having said that, there are two remarkable values to this set of materials, at least in my use of them and in my view of them. One is that it showed me how the world looked to Justice Brennan. So even if I don't actually know whether Justice White was thinking about changing his vote, I know that Justice Brennan was operating on that assumption, and to the extent that that makes a difference to whatever story I'm telling, that was extremely helpful and extremely worthwhile. The other thing, and this is maybe more remarkable, is when justices talk to one another, there's no record of that anywhere. In my wonderful tour of the Clinton Library, I saw the loose-leaf volumes of Clinton's daily schedule, which is an incredible resource, but no discussion between two justices would ever show up on that daily schedule. It was usually spontaneous. Justice Powell would call Justice Brennan and say, I have some concerns about your X opinion, can I come down and chat? And he'd come right down and chat. And that's not on anybody's calendar or schedule. There's no record of those meetings or conversations anywhere. So this 30 years worth of material from Brennan is really a remarkable resource in that regard. and gives an awful lot of insight about how the Supreme Court works. Now, having emphasized that part of it, the interchange among the justices personally, let me shift gears a little bit and talk a little bit about what I learned from Justice Brennan about the court, because it sort of contradicts the point I was just making in a sense. While those meetings and discussions and conversations among the justices do take place and are important, that's not really how the Supreme Court works. The way the Supreme Court works, and sadly this is probably less interesting than the mythical image of the court, but the way the Supreme Court works is in writing. The justices draft opinions, their clerks draft opinions for them. They work those drafts over in their chambers. When they're ready, they send them around to the other justices. Those justices write back letters to one another. Those letters take wildly different forms. The simplest letter is a very straightforward, there's an odd, and nobody seems to know what the origin of this is, but there's an odd grammatical syntax in the way they write to each other. When I want to join somebody's opinion, the memo I write back says, "Please join me," which isn't how you would actually say, "I want to join you," right? But that's the custom. You write a little one-line letter that says, "Please join me," or "Please join me in your fine opinion." That's the easy ones. If you get 4 of those, you're done, right? Walk in the park. The more interesting ones, for much of Justice Brennan's tenure after the Warren Court, right? Brennan joined the Warren Court in 1956. The Warren Court ended in 1969. Warren Burger became Chief Justice in 69 and served until 86. During most of that period, starting in 1972 to 1986, about 14 years, a justice by the name of Lewis Powell was the swing vote. The same way that everybody thinks about Anthony Kennedy. Anything you read about the Supreme Court today says it's all about winning Anthony Kennedy's vote. Lewis Powell was the Anthony Kennedy of the 70s and into the mid-80s. Lewis Powell would write back to Brennan. Powell was a Richmond lawyer, very kind of courtly Southern gentleman. He would write back the most lovely notes to Brennan that said, "Dear Bill, I think you've done a splendid job with the difficult issues in this case, and I'm so close to your views that I'd love to be able to join you if you could just see your way clear to making a couple of small changes." And then it's like a 9-page single-spaced letter that Brennan has to figure out how to deal with. But, and here's part of the magic of Justice Brennan and why I think he was so successful. Supreme Court justices can approach that role in different ways. There are some justices who basically think, "I'm right. If you agree with me, you'll join me. If you don't agree with me, I may not win, but it's your loss. I'm still right." Right? I don't really care what you think. I'm not going to make changes to accommodate your view because I'm right, period. Brennan was exactly the opposite. Brennan had a vision of where he wanted to get. He knew that there were certain constitutional rights and values that were not being adequately protected in our system and that needed to be brought more fully under the Constitution. And he would do whatever it took to accomplish that. He would negotiate until he was blue in the face, if that's what it took to win, because that victory was advancing that constitutional value. So to Brennan, that 9-page single-spaced letter from Powell was the beginning of a dialogue. However daunting it might seem to have to make all of these changes listed in 9 pages, not a problem. It's when you don't get that letter that there's a problem, because that means that that justice isn't interested in talking to you about your opinion. Once you're in play, so to speak, once you know that you've got 3 votes already, which he often did, and that Powell is going to be the 4th vote, and with Brennan making it 5 votes, then you have an opportunity to work the issue, to negotiate, to compromise, to try to find a common ground that allows you to have a majority. And Brennan really raised that process to an art form. The first thing he would do when he knew that he was writing an opinion, when he was assigned to write the majority opinion for the court, would be to send his law clerks to talk to the law clerks of whichever justice was the key vote in that case, to say, what's on your boss's mind? What's it going to take to have your boss go along with this outcome? Again, not all justices do that. Some justices, Chief Justice Berger, in his years on the court, forbade his law clerks from talking to anybody else in the building about what was going on in his chambers. Contrast that to Brennan saying, go forth and find out what's going on in the other justices' chambers. I want to know what they're thinking and what's on their minds. So to Brennan, the notion of how to get the court to coalesce around 5 votes was really what it was all about. Not in an unprincipled sense, not in the sense that anything 5 justices wanted to do was right, but he had a notion of what he thought could be accomplished in any given case, and he was willing to go to great lengths to try to accomplish that. Let me give you an example. Before 1973, the Supreme Court, for the most part, had never found that gender discrimination was a violation of the Constitution. Race discrimination, we knew, violated the Equal Protection Clause of the 14th Amendment. Gender discrimination, for the most part, did not at all. It just simply did not trigger the Equal Protection Clause of the 14th Amendment. Justice Brennan in 1973 wrote an opinion in which he essentially argued that gender discrimination should be treated pretty much the same as race discrimination under the Constitution. Same history, same difficulties, same problems that it poses to our society, same impact on women. Let's treat it the same as race discrimination. He couldn't get 5 votes for that. He only got 4 votes for that proposition, in part because the Equal Rights Amendment was then pending, and Justice Powell, the one I mentioned earlier, who was the swing vote, said, well, you know, if that's going to be the case, why don't we leave it to the constitutional amendment process? Why do we, the court, have to do it? So Powell wouldn't go along, and Brennan couldn't get 5 votes. 3 years later, the same issue came back in a different case, and Brennan tried again, this time said, well, let's treat gender discrimination as a violation of the Equal Protection Clause, not exactly on the same level as race discrimination. Let's use a slightly lesser standard to measure gender discrimination, but let's bring it under the Equal Protection Clause. Excuse me. Now, some people would say, gee, isn't that a defeat because he didn't get what he wanted in the first place? To Brennan, the answer is absolutely not. He brought gender discrimination under the Equal Protection Clause. Gender discrimination today, in many circumstances, is a violation of the Constitution because Brennan kept trying until he could get a 5th vote that was willing to compromise on a lower standard and make it a violation of the 14th Amendment. To me, that's sort of vintage Brennan. That's what it was all about. He believed that there was a constitutional problem. If he couldn't get the court to go along with attacking that problem exactly the way he wanted to, then he'd compromise and try something not quite exactly the way he wanted to, but he won. And there are examples of that across the board, just countless examples where Brennan did that and persisted. Now, how did he do that? We've talked a little bit about this willingness to compromise, and I want to talk about an aspect of this that I think was very important to Brennan himself. I don't know how many of you read or remember the book The Brethren that came out in about 1980, that was sort of the first book that kind of penetrated the secrecy of the Supreme Court. It was by the Pulitzer Prize winning author Bob Woodward, who then was fresh off toppling President Nixon after Watergate, and was sort of this incredibly influential national figure. And he wrote this account of the Supreme Court which drove Brennan absolutely crazy. Because if you read the Brethren carefully, it makes it sound like it's no different. It's basically members of Congress wearing black robes. It's sort of 9 politicians running up and down the halls, lobbying each other, trading votes, slapping each other on the back, and reaching results that just happen to be about legal cases instead of about tax bills in the House or Senate. Brennan just felt so deeply that that was a misrepresentation of the court that he talked about that with me over and over and over again. Now, the point here is not to be naive. Yes, there's politics in the Supreme Court. I know that comes as a great shock to everybody. Of course there's politics in the Supreme Court. But it's not really the way the justices work. The justices, for the most part, are not sitting there with political agendas checking them off. You know, I ran on this platform. I still have 5 more things that I have to accomplish. The justices don't get up in the morning and say, which of my personal biases can I write into the Constitution today, in the way that you might expect a member of Congress to say, okay, what do I think will serve the interests of my constituents today? It's a very much different process. Brennan in particular sort of suffered in this depiction in the Brethren because he was a kind of short, jaunty individual. The Brethren would have you picture this sort of leprechaun walking up and down the halls, and all he had to do was throw his arm around Lewis Powell, and Lewis Powell would melt, change his mind, and vote in favor of something that before Brennan put his arm around him he'd been totally opposed to. And that's all sort of silly. What Brennan did was work at it. He spent enormous amounts of time with his law clerks trying to think about how to approach a case in a way that might get Lewis Powell's vote, and how not to go too far, but still far enough to achieve Brennan's goals. He did it in writing, the way everybody else did. Now, it's not to say that there isn't some truth to the myth. He was incredibly charming and gregarious. And in the notion of being at a school of public service, let me add a thought about that. I mean, one of the things that held Brennan in such good stead for his whole 34 years was that he got along incredibly well with everybody. He never fought with anybody. He never said a cross word to anybody. He interacted in a positive, supportive, cooperative, collegial way with every justice he ever worked with, from I mean, let's take the whole gambit, from the Chief Justice down to the cleaning crew at the court. They loved Justice Brennan because he treated them all with respect, with kindness. He got along with them. And there's a lesson there, I think, about public service that we don't see enough of today, that kind of collegiality makes a difference, that it really makes things work better. And in Brennan's case, this is not a zero-sum game. It helped him accomplish what he wanted to accomplish, too. So Brennan's closest friend on the court during the Warren court years, for Brennan 56 to 69, was Justice John Harlan, the person that he disagreed with the most during those 13 years. John Harlan was probably after Felix Frankfurter retired in 1962, John Harlan was probably the most conservative member of the court for the next 7 years. Actually, he served a couple of years more, so he and Brennan were together for another 9 or 10 years. And they were very good friends, even though they had absolutely diametrically opposed views. They got along wonderfully and made a point of it. I think that's really an important thing to remember. I want to take about 5 more minutes and then make sure we have plenty of time for questions and discussion. Let me talk a little bit about Brennan and public service. Brennan was not a politician. It is often described in writing about him, he's saying Brennan who had a political background. He had no political background whatsoever. His father was an elected official in Newark. His father was a union leader who worked his way up through the ranks to become a union leader and then ran for the elected city commission in Newark and became the police and fire commissioner. So his father was a dedicated public servant for about 12 years. Brennan campaigned once or twice with his father and really didn't have a taste for it at all, didn't like it at all, and decided that politics really wasn't for him. His public service consisted of a number of different things. For his generation, the most obvious one was that he volunteered for World War II. He didn't go overseas. He was sent to Washington and worked in the Army labor and personnel divisions, where he, as a lawyer, was responsible for dealing with all kinds of personnel management issues and basically converting domestic industries to wartime production and some of the labor issues that came with that. And I think it gave him an appreciation for a whole range of issues that he might otherwise not have been exposed to. He spent about a year of that time in California trying to get industries to convert to producing parts for military tanks and trucks and planes. And much of the workforce he was dealing with there, by definition, were women, because the men were overseas. And so he, in the 40s, found himself having to deal with issues like child care for working women, which were, very novel sorts of things to face at the time. He tried toward the end of the war to get sent overseas, but the war pretty much ended before he could do that. When he went back to New Jersey, he quickly, within about 2 or 3 years, got involved in an effort to rewrite the New Jersey state constitution, and spent a lot of time on that, although he was in private practice. The heart of his public service, obviously, was as a judge. In 1949, he was asked to become a trial judge in the New Jersey state courts, a superior court judge. He took a pay cut from his law firm salary of about $80,000 a year to his judicial salary of $25,000 a year. Two things about that decision. One is he never looked back, and two is he was broke for the rest of his life. He literally, until well into his Supreme Court tenure, was in debt, in part because of the pay cut. But he never looked back. He absolutely believed that the judiciary was a wonderful opportunity. He was totally devoted to it, both in New Jersey and the U.S. Supreme Court. If he hadn't been appointed to the U.S. Supreme Court, the Chief Justice of the New Jersey Supreme Court, a legendary legal figure named Arthur Vanderbilt, had let it be known that he wanted Brennan to succeed him as Chief Justice of the New Jersey court system, which Vanderbilt died the year after Brennan went on the U.S. Supreme Court. So if Brennan hadn't gone on the U.S. Supreme Court within a year, he probably would have been the Chief Justice of New Jersey. And again, he never looked back. Now, his motives, there are different theories about his motives for becoming a judge. Maybe they're not the most noble in public service terms. One theory is that he had a family, a growing family, and was working so hard at his law firm that he had no time to spend with his family, and that becoming a judge would actually give him more control over his time and his schedule and more ability to see his kids. That's one explanation. The other explanation was his father, as I said, had been a labor leader. Brennan was working in Newark at a management side labor and employment firm, basically litigating against the unions. And some people say, well, gee, it made him incredibly uncomfortable, and after a while he thought this was a good way out I'll go become a judge and I won't have to keep litigating against the unions anymore. Again, maybe those aren't the most noble motivations for becoming a judge, but as I said, he thought it was a wonderful profession and really never looked back. Let me close with a couple of observations about one of the most surprising things that I found in doing the research for the book. And I think this is a fascinating observation about judges in general. The judiciary today seems so much a subject of political debate and polarization. We fight so hard over liberal judges and conservative judges, and are they voting their own consciences? Are they writing their own views, or are they really following the law, and how do we tell, and so on. One of the most interesting revelations about Brennan was to discover that this legendary liberal judge was actually somewhat more a conservative figure in his personal and private views, which to me suggested the image of a good judge, that there was a tendency to think, well, gee, he's a liberal guy who's writing liberal decisions that reflect his liberal views. Not entirely so. What I discovered was several examples. One is that while Brennan always, 100% of the time, voted in favor of abortion rights as the Supreme Court justice, privately he considered himself a fairly serious Catholic who told me in the interviews, if my daughter had come to me and told me she was pregnant and asked my advice, I would have done everything in my power to talk her out of having an abortion. I don't particularly care for the practice of abortion. It offends my religious sensibilities. That's one example. A second example is I think it's fair to say there is no greater defender of freedom of the press ever in the history of the Supreme Court. Privately, Brennan hated the press. He thought they were sort of scurrilous and immoral, would violate people's privacy on a dime. Got into fights with reporters. I mean, he wrote the most famous freedom of the press decision ever in the history of the country in 1964, called New York Times against Sullivan, which gave the press extraordinary protection in libel cases. So that even if the press got it wrong and did in fact libel somebody, that wasn't enough for a public figure or a public official to recover from the press. You had to actually prove that the press had sort of done it deliberately and recklessly, not just that it made a mistake and damaged somebody's reputation. That was a huge amount of protection for the press. Within that same year, he was invited to the University of Miami to give a lecture and meet with students, and there's a letter that outlines everything they asked him to do, a dinner, a reception, alumni, students, faculty, teach a class, and hold a press conference. And he wrote back and said, you know, this looks like a wonderful schedule. I'd be delighted to do everything you've asked except hold a press conference. I've found that it's much too easy to be misquoted or taken out of context by the press, and so I prefer not to speak with them. This is, you know, at exactly the same time that he just wrote this opinion protecting their right to take you out of context and misquote you, essentially. So there really was a private man. There are other examples, but I don't want to eat into all the Q&A time. There are other examples, but he really was an individual who had a separate set of private views, but who I think developed a profound vision of what the Constitution was supposed to be about, that the Constitution was supposed to be about protecting the individual dignity of every human being, and that's the way he went about the job of justice. And that's, I hope, the story that the biography of Justice Brennan captured. So thank you very much, and I'd be delighted to have your questions.
We do have time for some questions. Wait for a microphone first. Thanks.
Thank you for being here. Justice Brennan is often associated with this school of thought called living constitutionalism and contrasting with Justice Scalia. Is that a fair sort of placement for him? And is there any indication that he and Justice Scalia ever talked about these various theories?
Thank you. It is a fair placement for him, although I think he didn't like the term living constitution, and he didn't really use it himself, although it is associated with it. He's the sort of paradigm for that vision of the Constitution. But probably one of the most famous speeches he gave, he was a speech at Georgetown University in which he said, "I interpret the Constitution in the only way I can as a 20th century American. I can't pretend to know what was in the minds of people who are long dead and gone." And that's sort of, that's another way of saying a living constitution. What I think he wouldn't have liked about the phrase living constitution is that when, and I certainly don't mean you, but when people use that phrase, particularly when they use it pejoratively, they really are describing, in a sense, their vision of somebody who thinks the Constitution means whatever you want it to mean on this day at this moment, and you can make it up as you go along. And Brennan, I think, very, very strongly felt that that's not what he did, that his constitutional vision was a kind of consistent philosophy built over time that evolved from building on one case to the next, and was certainly not some notion of kind of made up, whatever your whim of the day is. He and Scalia were actually good friends. They enjoyed each other's company. They were together on the court for about 4 to 5 years. Scalia trusted Brennan's, and this is sort of, given all the debate about ethical issues when Scalia gives this speech or makes this comment or that comment to various political groups, he would consult Brennan when Brennan was still there about the propriety of going to talk to different groups or appearing at different events, and trusted Brennan's sort of wisdom and experience over that, and so they were good friends. I don't think they talked specifically in sort of broad philosophical terms. Brennan did tell me that Scalia, and this sort of touches on the point, there's, as I'm sure you know, a whole line of debate about the 11th Amendment to the Constitution, which was originally passed to limit the ability of somebody from one state suing another state. And that's what the language of the amendment says. But the Supreme Court about 130 years ago said, well, if somebody in Georgia can't sue the state of Arkansas, then it would make sense that somebody in Arkansas also can't sue the state of Arkansas without the state's permission. Well, I mean, it's not what the amendment says, it's not what the amendment was about, it's not what the amendment was intended to do, it's not the case that the amendment was intended to rectify, but the Supreme Court ruled that, and Brennan, for about 30 years, tried to get the court to overrule that 1890 decision and say it was wrong, that that's not what the amendment meant. It's not even what the language says. Scalia came to Brennan early in his tenure, in about 1987 or 88, privately, and said, Bill, you're right about the 11th Amendment, but I can't join you because it's now been precedent for 90 years, and I can't, as somebody who's supposed to respect precedent, I can't bring myself to join you and advocate overruling this 90-year-old precedent, even though I think it's absolutely wrong. So there was maybe a little more intellectual common ground than might be obvious externally.
Fran.
Thank you for coming. In your experience in writing about Justice Brennan, and I'm assuming in one regard he's typical of most justices, when they leave the Supreme Court, they take their personal papers and writings with them. when they're finished with them, and if the family no longer wants them, what usually happens to their judicial papers and writings?
It's a good question. My wonderful tour guide, Bob G., and I were talking about this morning, because there's a federal statute that governs what happens to presidential papers. There is no statute that governs what happens to Supreme Court papers. So they are entitled essentially to do whatever they want with them. For the last maybe 40 or 50 years, many justices, maybe most justices, have donated their papers somewhere, but some of them have sanitized them, thrown away stuff before they did that. They can impose whatever kinds of restrictions they decide. So Justice David Souter, who retired a couple of years ago, gave his papers to the New Hampshire Historical Society, sealed for 50 years. So I don't know about you, but I won't be there when they open up. I just, I guess on Monday of this week, was at the Library of Congress looking at the papers of Justice Byron White, which just opened last week. And sadly, before he donated his papers, I mean, the justices all have these kind of storage closets down in the ground floor of the court where they send stuff that they no longer have room for in their chambers. And somewhat famously, Justice White apparently went down there for a week after he retired and sat there with what they call burn bags, you know, big brown bags that the court staff then takes and has burned. And he sat there with burn bags throwing stuff away until he was satisfied that, I mean, this is my comment, I'm sure it's not what he said, but until he was satisfied that there was nothing left that was interesting in the papers. Brennan didn't do that. Brennan didn't really sanitize the papers. It's a pretty full collection. There have been some restrictions on them which are about to end. Pretty much, I think his personal correspondence files are still closed till 2017, but everything else in his collection opens in July at the Library of Congress. There are many, I mean, Marshall, Douglas, Black, Frankfurter, Warren, Brennan are all at the Library of White are all at the Library of Congress, Blackman. Others are spread around the country. Souter's is going to be in New Hampshire. John Harlan's is at Princeton. Tom Clark's is at the University of Texas Law School, and so on. But I think it's, on the one hand, I don't want to advocate chilling their deliberations in a way that they're worried about what they're saying to one another. On the other hand, I think it's a shame that there isn't any standardization of what they are expected to save for history. And then there's all kinds of subsequent, you know, now they're emailing one another, and I'm sure they're not saving the emails, so.
Yes, sir.
In the case of Cooper v. Aaron, where Justice Brennan commandeered a quote-unquote unanimous decision, Justice Frankfurter waited until the decision was announced and then wrote his own quote-unquote concurring decision, apparently aimed at Southern moderates.
Right.
Do you think that had its intended effect?
No, I think it was delusional, to be honest. So Cooper versus Aaron is the only, that's the Little Rock Schools case in 1958, which Brennan was the principal author of. That's not apparent publicly because it's the only opinion in the history of the court that is actually signed as if it was written by all 9 justices. So usually an opinion says, you know, the opinion of Justice Brennan joined by the following justices. This one says the opinion of Chief Justice Warren, Felix Frankfurter, Hugo Black, William O. Douglas, all 9 as if all 9 wrote it. And that was deliberate as a show of force to try to suggest to the resistance against desegregation that the court was, you know, was not wavering, that there was no, you weren't going to find any harbor in the court for for the effort at resistance. And the court very much wanted to speak unanimously with one voice, and it wasn't until the very end of the deliberations that Frankfurter suddenly announced that he was writing a concurring opinion. They tried and tried to talk him out of it. In fact, Brennan and Black, I think, was it? Yeah, Brennan and Black wrote a kind of semi-mock, semi-serious concurrence to Frankfurter's concurrence, trying to embarrass him and say, you know, the opinion of the court is the one we issued last week. The one that's being issued today has no significance. They decided better than that it wasn't really a good idea to issue that opinion because it would actually call more attention to Frankfurter's opinion. But Frankfurter believed that as a former Harvard Law School professor, and with many of his former students practicing law around the country, including in the South, that he could somehow appeal to their common sense and goodwill and get them to see that what was happening in Little Rock was not the right thing, and that one should be obeying the Supreme Court's mandate and not resisting, and that somehow they would listen to him more than they would listen to the court, and that this would help the whole effort. I mean, I think Frankfurter was genuine in convincing himself that that was the case, but I don't think it made any difference whatsoever. I mean, do you have a different view, or?
Taking a course right now that Tony Fryer used to teach here. It's on legal history and reading his book. And then I picked up yours. And so they dovetail with respect to that.
Right.
But there's no, I mean, who knows exactly what kind of echo effect that had. So I was just wondering how you were feeling about that.
Yeah, I've never seen any evidence that Frankfurter's effort made any difference. Yes.
We tend to think of our justices as being decisive and resolute. And I'm wondering if in your 60 hours of working with him and going through his papers, he ever shared with you any indecision, any regret, second thoughts about any decision? If so, what was that decision?
There's only one fairly obscure example. He, for somebody who was relatively reflective and extremely unpretentious and very kind of open and thoughtful, he was not much for looking back. The only time he ever acknowledged to me what he thought was a mistake was the actual standard that he adopted in New York Times against Sullivan. And New York Times against Sullivan, which is the libel case that I mentioned earlier from 1964, the court used a legal test. The court basically said, you cannot recover damages against the media for libel unless you show what he called actual malice. And that was the term of art. That was the legal term. And actual malice meant either reckless disregard for whether something was true or not, or knowing that it was false. That was the definition. So that's kind of the legal jargon in the decision. And Brennan said later that he regretted using the term actual malice because juries couldn't distinguish between malice, meaning spite or malicious conduct, and the legal definition of the term actual malice. And so it was very confusing to juries, and he was sorry he had picked that definition. That's the only real kind of hardcore concession he ever made about making a mistake.
Last question, Mary Jane.
How do you think Justice Brennan would view someone like Ron Paul, like presidential candidate Ron Paul?
I don't know how to answer that. I don't think he would have agreed with Ron Paul about a lot, but Justice Brennan, in spite of not liking newspaper reporters, he was extremely well read, so he would have followed the campaign closely. He would have read about Ron Paul in the debates and in the different issues, and I think would have been extremely well informed about him, but I don't know what his actual take. I mean, he actually tried very hard to stay out of politics. Interestingly, he made a point of not voting in presidential elections. It started by accident when he was appointed to the Supreme Court in 1956. It was late September, early October. He didn't get an absentee ballot from New Jersey, and he couldn't vote in Washington, so he didn't vote for Eisenhower or Stevenson in the. But I mean, I think Brennan would have viewed that as being political, and so would have kind of kept his distance from engaging with that at all. I mean, it was not his view of, it was not Brennan's view of how to interpret the Constitution, but he really didn't express a lot of views about political figures and what they were doing, I think. He was careful about that.
Thank you so much for making your first visit
Thank
to
you.
Arkansas.
Thank you for having me.